news.com, facebook.com, youtube.com, and x.com. You may also be listening to us live on 392.7 FM. If you'd like to be a part of the program, remember to use the hashtag Ghana Tonight. Let's bring you Ghana Brief now.
Former Chief Justice Gertrude Tokonu has filed a case at the High Court challenging the processes leading to her removal as Chief Justice and Justice of the Supreme Court. She is also seeking to halt the consideration and appointment of a substantive Chief Justice. She argues, amongst other things, that the committee's work, including its recommendations, were unlawful and should be declared null and void. Lawyer for Kwabena Edubuahin, the former National Signals Bureau director, has described the third accused as having double standards after she agreed to be a prosecution witness. The High Court discharged Mildred Donko after the prosecution filed a notice of withdrawal, dropping all charges against her. But reacting to the development, Samuel Atachia described Mildred Donko as being two-faced.
I never knew that there's a lady who was capable of double standards. I never believed that somebody would say that, oh, my mouth is in another man's kitchen, but today, for the sake of my freedom, I'm going to betray that person. But what is she going to betray us with? That's the whole point of the matter. What does he know that if he should come into the public space, the case will go against us? We are not scared about it. But you see, the obvious lofty prostitution is what should worry the Attorney General. The Attorney General is comfortable with a woman who will speak with two mouths. We'll see how she will fare under cross-examination.
Ghana has signed a memorandum of understanding with the government of Grenada to facilitate the recruitment of Ghanaian nurses to work in Grenada. The agreement aims to strengthen the healthcare systems of both countries while promoting cultural exchange and knowledge sharing in the medical field.
In the health sector, Grenada's interest in recruiting Ghanaian nurses and allied health professionals presents a valuable opportunity for structured collaboration between our two countries. Ghanaian health workers have gained international recognition for their professionalism and their compassion, and we're keen to explore arrangements that address both our national needs and Grenada's health priorities.
Government is preparing to prosecute culprits in the ECG missing containers saga. This comes at a time when the Energy Ministry reports that 1,500 of the retraced containers have been cleared from the port. The Minister of Energy and Green Transition, John Jinapo, is confident that the law will take its course to bring all perpetrators to justice.
The taxpayers' money must be accounted for. Nobody would allow this in his or her company. We shouldn't have been there. If ECG was your company, and you were the shareholder, and you invested money in it, and your management came to tell you that they've awarded contracts about 9 billion, when the board approved contracts for just about 3 billion. It's been a very, very difficult task. But like I said, we should never go that path again. And as minister, I will not tolerate that. If it happened in the past, it must not happen today.
Starting January next year, the Driver and Vehicle Licensing Authority (DVLA) will begin re-registration of all existing vehicles. The exercise will involve the issuance of new vehicle number plates with enhanced security features. Following the government's resolve to reintroduce toll collection systems on some roads, The proposed number plates have been designed to conform to the automated security features of the yet-to-be-constructed toll booths. Julius Neti-Korte is the CEO of DVLA.
We are paying for only the number plates. Currently, we pay 118. That's 118 Ghana cedis. But because now more security features are going to be added to this one, it is highly possible it will go up a little bit, maybe to 130 or maybe to 120. We don't know, but we'll engage and let the public know the exact or specific amount they are supposed to pay. And no one should pay more than that. And don't go and pass through any Guru boy. Come to DDLA. We are opening our services. We are opening more branches.
We'll spend considerable amount of time in the courts, and if you're guessing what the next topic of discussion is, your guess is probably right, because coming up now, former Chief Justice Gertrude Tokonu files yet another lawsuit seeking far-reaching reliefs. I've got the details for you. Let's get into that right now. Now, as you very well know, at this time, the former Chief Justice Gertrude Asaba Tokonu is making a new attempt at the High Court to overturn her removal. Now, hear this. She is also moving to stop any processes for a successor. I have literally lost count of how many attempts she has made so far since the beginning of the entire impeachment process up until today. Maybe half a dozen. That sounds about right. Now, I've got to tell you also, all of those have been unsuccessful, but that has not stopped her from calling out the actions of the committee once again. So let's get into what she's asking for this time. Now, let me tell you beforehand that some of the things she's naming again, we already know about. But we'll hear her because she has the right to do what she's doing. Dennis Poberi is my producer. He's been combing through the entire document that we have here. He'll share some details with us. Dennis, what else are we learning, on the subject of the Chief Justice and what her concerns are and what she's seeking from the court this time?
Well, so let's just start by saying that this will be the 7th action that she's taking in respect of the entire proceedings before the committee that relates to her removal. This time around, she's seeking that the court intervenes to quash all the proceedings that took place before the Justice Poorman Committee, including its recommendations and the outcomes. She also wants that the warrant which removed her from office also be brought up to the court for it to be quashed. It doesn't end there. She's also seeking that all considerations leading to the appointment of a substantive Chief Justice also be put on hold for this matter to be looked at. And of course, she also talks about her entitlements and that any attempt to deny her of her entitlements all through from the time to the point that she was given the removal letter should also be put on hold in that particular respect. I mentioned 7, but let's go back and see exactly how the other issues have panned out. You do recall that as far back as May 2025, that was the first time she herself, a writ of summons in her name. We had seen some previous 3 attempts at the Supreme Court, but they were not in her name.
Right.
But this May 21 was one that was in her name. Subsequent to that, she filed an injunction to stop the process. That was when the committee had started its work. That injunction application was unanimously dismissed. Then fast forward to June 2025, there was a judicial review at the High Court which was dismissed. This judicial review was to the effect that the processes before the committee were infringing on her rights, for which reason she wanted the court to intervene and stop but the court dismissed this particular application. In July 2025, she filed a case at the ECOWAS Community Court in respect of the proceedings that were before the committee. And this matter is still pending because there was a point where they had to determine some preliminary matters, which we have already explained, the kind that would be the same as injunction applications in our jurisdiction.
Right.
The court had to adjourn indefinitely to make a ruling. That is still pending. So we still do not know the outcome of that particular matter. Again, in July, there was also a judicial review again, which was seeking to declare the Shining Stars of Ghana, one of the petitioners, as non-existent in fact and in law. That application would later be not withdrawn. There was an attempt to withdraw by her lawyers because at the time they had gone to hear it, she had already been removed. So there was an attempt to orally withdraw from, but the court refused that this was a process that was duly filed, so they should come proper, meaning they should file another process to withdraw it. We've since not heard about that application. The sixth one was an application that was filed, not a writ of summons, at the Supreme Court. This time around, she was challenging her removal as the Justice of the Supreme Court. Her contention in that suit was to the effect that, yes, you have removed me as the Chief Justice, but I should still be allowed to continue as a Justice of the Supreme Court. That matter is still pending before the Supreme Court. Now, today we are learning that she has filed a new suit at the High Court, this time around, seeking to quash the Justice Palmer's committee's proceedings, its outcomes, and also to halt the appointment of a substantive Chief Justice. 7 lawsuits in all, gearing towards her removal and seeking that, the point she essentially makes is that all the processes that she's gone through, they are unlawful. They should not have, she should not have gone through all that.
Even in this new challenge,
Yes, in this new challenge. And just to point out a few things in this particular one for you, especially in respect of the matters that she raises, she talks about some 3 reasons that the committee recommends based on which she was removed. She says the committee gave 3 reasons. In fact, one of the reliefs is that those 3 reasons should be brought to the court for them to be quashed. Now, what were the reasons? She reproduces them. It had to do with the travel expense of the Chief Justice. She was alleged to have gone on some travels that she was not entitled to, and she got some monies. That's one. The second one has to do with transfer of a judicial officer by name Mr. Francis Baden. And the third one had to do with a recommendation of some judges for consideration for elevation. This had to do with some judges who were recommended to be appointed to the Supreme Court. Now, these are the grounds for her argument in respect of these 3 reasons that she talks about. So she makes reference to the first one, that the first finding is false. That is the one that has to do with the travel expense. That the first finding is false, misleading, irrational, and illegal because it cites misconduct for expenditure that was neither disallowed nor surcharged by the Auditor General. So she mounts her argument on the Auditor General's report, and she says that this expenditure for which the committee says that she had done something wrong was neither disallowed nor surcharged by the Auditor General. Still on that point, she argues that the first finding is also unreasonable and unfair because it attributes unauthorized expenditure to the Chief Justice, though she neither authorized nor administered it. Essentially saying that whatever monies were paid to her, she was not the one who authorized it, or she was not the one who paid such monies.
And some of these arguments, Dennis, have been made before in the past, in support.
In separate fora.
Absolutely.
Yes, so now she's appearing before the High Court in respect of this judicial review. These are the grounds on which she's coming. Now, the third one, this addresses the second issue. The second issue has to do with the transfer of the judicial officer. She says that that second finding is an abuse of power and unconstitutional as it wrongly treats the Chief Justice's lawful administrative duties under Article 1254, including the transfer of judges and officers, as misconduct. Essentially saying she has a constitutional right at that, to do whatever she did, including the transfer of judicial officers, and that includes Mr. Francis Baden in this particular instance. Also on that third one, which also refers to the transfer of Mr. Francis Baden, that the third finding is an abuse of power and unconstitutional, as it mischaracterizes the Chief Justice's legitimate role under Article 1254 and established convention in judicial administration as misconduct. Sorry, this third one refers to the recommendation of the judges for elevation.
Right.
She says that when it comes to these two, she has that legitimate role under the Constitution to make such recommendations. And to that extent, for the committee to have construed that to mean it's a misconduct, she finds it very problematic. The last one we'll look at, in fact, there are a lot, but we just picked 5 of them, which addresses all the 3 issues that she talks about. That the third findings also unlawfully challenges the Chief Justice's conventional rule, shared with the Ghana Bar Association and the Attorney General in recommending judges for promotion. To also say that, yes, she has a constitutional rule and she also has a conventional rule. And that conventional rule of recommending justices or judges for promotion, she shares it with the Ghana Bar Association and the Attorney General, and I'm guessing she's making reference to the Judicial Council.
So basically, she's saying, I don't do this alone.
Exactly. And that for the committee to have come to a conclusion that by virtue of her making those recommendations, it amounted to misconduct, she does not agree. So in essence, she's saying that 1, the whole proceeding should be brought to the court to be quashed. The reasons given should be quashed. The attempt to nominate, the nomination has already been done. We do know that for a fact. The next phases will be...
But to continue with the process.
Yes, the next phases. I mean, that's in respect of the substantive Chief Justice.
Yes.
Because part of the suit says that the consideration and appointment should be halted.
Absolutely.
But what I'm saying is that...
And that coincides... Well, you finish what you're saying.
Yes, what I'm saying is that already there's a nominee. The next phase for that nominee, who is the person of the acting Chief Justice, His Lordship Justice Paul Bafuboni, the next phase for that process will be vetting process and then the appointment itself. But she says that...
Even the consideration too.
Should be put on hold.
Right. And this coincides with a petition that had come up earlier against the acting Chief Justice.
Yes. So there's also that petition, except not much has been heard about it.
Indeed.
Only to hear that the petitioner himself has indicated he submitted that petition to the presidency. But usually when those petitions are submitted and the presidency will acknowledge receipt and make communications on that, we haven't had any communication on that particular one. It's not the only person. His Lordship Justice Yoni Kolendi, there's also reports of another petition in there.
Absolutely. It sounds like a hot mess in the judiciary at this time.
Precisely.
Is there anything else you're sharing with us tonight?
I mean, that will be it for now on this particular matter, because we're still having to deal with quite a number of legal matters. Because we're in court today. It was a busy day in court.
Indeed. But even before we go to the other legal matters, Dennis, we know that Austin Bracco Powers, private legal practitioner, has been reacting to this latest development from the Chief Justice. Let's take a listen to him. We'll come back and then have a conversation on the back of that as well. Don't go away.
If you will notice, if you follow the trajectory, you will notice that this is part of the checklist of the Chief Justice to bring sanity and to make sure that the right thing is done. I have said in the beginning that the processes triggered to get her out at issues. And I think she's just trying to get the right thing done. We should not falter, because whatever she's doing for the entirety of Ghanaians, so that tomorrow someone else who may be given the opportunity to occupy that particular office will also benefit from her work. I think she's doing the right thing, even though she believes that the president has a constitutional duty under Article 146 to set up a committee. She believes the right thing must be done. And for me, I think this is the right process she must do. We need to get to the bottom of this. The fact that she had been given a warrant of removal should not bring closure to the matter. We must get to the bottom of it, whether the allegations, so-called allegations made against her. In fact, if you've read action, the suit she just filed, you will notice a lot of things, a lot of claims that she has made, which for me, if those claims are anything to go by, it's those claims raise key questions about the work of the committee, the Article 146 committee. And for me, any court interested in justice, interested in making sure that justice is not only manifestly seen to be done, but justice is done, would have to go into this matter and deal with the matters as they are until we get to the bottom of it for everybody to be settled with that, whatever outcome we may have.
Austin Bracco Powers is a private legal practitioner. Let's now connect with the former director of the Ghana School of Law, Kweku Ansasare. Lawyer, good evening to you, and thank you for staying up for us tonight. Now, what Bracco Powers is saying is quite contrary to what you have told us. In fact, you have described the action as, or her and her action as irritant. And you have said that the seat of the Chief Justice is not a traditional stool. Why?
It is true that the office of the Chief Justice is not a traditional office. It is an office created by virtue of a constitution. But what is happening now, the former Chief Justice seems to be personalizing the issue. Now, my reaction to demand now that the president should have nothing to do with the anticipated vetting of for Bafuboni, it's laughable. It just reminds me of what the old lady said just before Nanado President Kufuor came to power. Mokwaya, Mokwaba, that's all. I mean, so this is a scenario of Mokwaya, Mokwaba. You have your day in court. You have the day before the Justice Court former committee. She was heard. The rules of natural justice, were observed. The president acted in accordance with the Constitution. Every step the president took, had the support of the Constitution. So I don't understand this. You are now saying that justice must be retained, to be done. Justice has been done and said. If it's a menu, it has been, said very well on former, Chief Justice Tokonu. It was tried. It wasn't, purple, and therefore, now that she wants to be reminded that all power or authority lies of God, you have to know that the people are speaking loud and clear.
I see, lawyer, just a couple of things.
Of the people.
Just a couple of things I want you to clarify for us. The first one being, when you say that her request for the consideration and the entire process really of Bafuboni as Chief Justice should be halted, is laughable. The question for me will be whether or not this is able to have any impact at all on that process. Is that why you think it's laughable?
Obama, my sister, you were appointed a Chief Justice. Something has happened. The president has acted in accordance with the Constitution to remove you. How on earth do you request or urge the president not to proceed to make a nomination to replace you? It doesn't like in a man to do that. It doesn't. It is the Constitution that is working. Now, if you have been removed in accordance with the Constitution, and every step taken in the process, had the support, of the Constitution, she cannot complain that she's been given a raw deal. Not at all. Now, she could have, in all humility, appealed to the president, but you see, she doesn't appear to have learned any lessons from what has happened. She has become too abrasive and irritant now. She's just irritating the nation. The nation's heartbeat is now rising. And I think that if she has, friends who love her, they should advise her to stop what she's doing.
I see. So, lawyer, as far as you are concerned, as far as you are concerned, these legal processes cannot stop the vetting of Bafuboni.
How can it stop?
Very well. The other thing I want you to clarify. The other thing I want you to clarify, counsel, is legally speaking, is she not able to challenge the decision of the committee's decision on her?
We are done with the committee. The moment the president accepted, the recommendations contained in the report, whatever the committee did, whatever the committee said, seems to be the act of the committee. Now, because the president has acted, it is now presidential. So let us stop talking of the committee and rather, talk about the president's decision.
Very well. So let me rephrase the question then.
Finality on the matter.
So I'll rephrase the question. Legally speaking, is she not able to challenge the president's decision to remove her after the facts?
It is devoid of constitutional support. It has no support under the Constitution. Article 146, clauses 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11 don't support any such cause, I'm afraid. Because nowhere in the 11 clauses has it been mentioned that after the president has acted on the report of the committee, it can be liable to another determination. No, there is finality, and once the president signed the signature sealed the case, so that determination was conclusive of the matter, and it cannot be reopened. This afternoon I said that the door has been shut. The key has been taken away. There's no window through which you can enter the presidential lounge as far as this matter is concerned. So if I were leadership properly, I would rather find an amicable way of coming to an end of this matter. So it's not showing any humility. He has to approach this matter and realize that he is dealing with the president of the republic. So this you think you are president, you wait and see. I was a former chief justice. Is he going to how long is he going to continue this? Is he going to continue until she turns 70? So that, she will go down in our history, in our records, as, a former chief justice who refused, to abide by the president's decision.
I see. So, lawyer, I've heard you say an amicable solution a number of times. What does that look like, an amicable solution?
You see, we have a council of state. We have a judicial council. Let us, not forget the fact that they are saving there. There are many of them, most of them are men of the world, women of the world, imbued with wisdom. At least, the president cannot pretend that he doesn't have friends among membership of the Judicial Council or the Council of State or even among the clergy. So what he should have done was to have appealed to the conscience, the good conscience of the president. I accept. I will respect the CG removal process pursuant to Article 146. But, however, I think that as far as my removal as a justice of the Supreme Court is concerned, I wasn't given sufficient opportunity to be heard on that. And therefore, if you can reconsider or review that and retire me so that I can at least, enjoy my retiring benefits. But the very aggressive and abrasive posture that he has, launched against the president, I don't understand. I have spoken several times. I have advised her several times. Please, you can't fight officialdom. Therefore, find a way, go and appeal, through some people to the president. He's a human being. He's the father of the nation. He will listen. But I think he's going to ECOWAS. Very soon, he'll go to United Nations. And then another one. But the truth of the matter is, all authority is divine. If the people have spoken, and there is some truism in the biblical assertion that the voice of the people is the voice of God, then if the people have spoken, God has also spoken. He's a Christian, and therefore Scripture has taught us some useful lessons that we live our lives by. And one of the Scripture lessons is that we should know when the end, is time. Once, you get to the end of the road, don't ask,
Very well.
Like the dilemma of a ghost. Where should I go? Should I go to Cape Coast or Egmina? Here, she must respect the Constitution.
Indeed, lawyer.
No two questions about that.
Lawyer, we'll end it here, but thank you so much once again for staying up for us.
You're welcome. Good night.
Good night. Kweku Ansasari is former director of the Ghana School of Law. Now, I told you earlier that we'll spend a considerable amount of time in court away from the Chief Justice's issue, the such Chief Justice's issues. We are also bringing you an update from the court regarding the third accused person who is now turned a prosecution witness. We'll tell you how that went down in court coming up now. Well, in other court matters tonight, counsel for embattled former Signals Bureau director is displeased as co-accused person has now turned prosecution witness. We reported on Thursday, if you recall, that the Attorney General dropped all charges against Mildred Donko, a former director of Advantage Solutions who is standing trial alongside Dubois. Now, in court today, prosecution announced to the court its decision, but the defendant's lawyer took issues with the manner in which the co-accused person has been turned prosecution witness. Let's take a listen to Samuel Atacha.
I never knew that there's a lady who was capable of double standards. I never believed that somebody would say that, oh, my mouth is in another man's kitchen. But today, for the sake of my freedom, I'm going to betray that person. But what is he going to betray us with? That's the whole point of the matter. What does he know that if he should come into the public space, the case will go against us? We are not scared about it. But you see, the obvious lofty prostitution is what should worry the Attorney General. The Attorney General is comfortable with a woman who will speak with two mouths. We'll see how she will fare under cross-examination.
Oh. Edubuahin's lawyer, Samuel Atachia, there, and, I pass no comments tonight, right? But I can also tell you the lawyer for the third accused person Eliklim Agbamava expressed satisfaction, contrary to what we've just seen, at the decision of the court rehashing Mildred's innocence. Take a listen.
Grateful to the court, for discharging my client. Generally, upon receiving a brief, I always believe that there was a total lack of mercy, to commit a crime. If you see, my client was not mentioned as being part of the crime of stealing. Her name only appears in count, I think 11 or 12 or so. 10, 11. 10, 11, yes. So it's pretty clear that in terms of the formation of whatever has gone wrong, she was not part of that conclave, to decide on anything.
Oh, we've got a bit more on this. Dennis is still here with me in the studio. He's a resident lawyer on Ghana Tonight. Dennis, much more happened in court today,
yes,
right?
Yes, precisely so.
So what else? What else is there to know apart from Mildred Ten prosecution witness and Samuel Atachian?
It appeared as though counsel didn't see it coming.
He didn't. You can tell.
He seemed a bit disappointed in the turn of events.
Absolutely, and I don't mean that to be funny, but
it's part of the practice.
Yeah, I absolutely agree. But it's so obvious that he didn't see that coming at all. And he thinks that his first reaction to it, that he never knew that a woman could be two-faced. Oh no!
That's just by the way.
Just by the way.
Yes, we mentioned yesterday, as part of this processes, the stage at which these cases, at the last agenda date, the court was set to give a ruling on an application that the defense had made. And this is the context of this application. They had made an application urging the prosecution to give them further documents. That application was opposed by prosecution, and the court ruled and dismissed that application. So they made an appeal. Having filed the appeal, they came back to the trial court to tell the court that we have an appeal pending. For that reason, let's put the proceedings on hold so that we can pursue that appeal. So the court was set to rule on whether or not to grant that application for stay. So the first thing that the court did this morning, even before the discharge of Mildred, was to give its ruling on that matter. And that application was dismissed. What essentially means is that the trial would continue.
Right.
And just to put on record, this matter is at a stage where they are at trial. And in law, when we say they are at trial, it means that we've got to a point where we begin to adduce evidence. So prosecution has started putting their witnesses in the box, cross-examination has started. But yes, of course, after that one, then the Attorney General drew the court's attention to the fact that they had filed a notice of discontinuing case against the third accused person that was done. She was discharged, her name struck out of the suit, and then the trial continued. So it does appear that in the absence of anything coming up again, this case is progressing steadily. So in respect of this matter, this is what has happened.
Some progress.
Some progress has been made in respect of that.
Indeed. So then I know the trial has begun. When the next time they go to court, what is likely to happen? The trial will continue. Because remember, prosecution has quite a number of witnesses. There are 4 witnesses. Yes, so they would have to put all those witnesses in the box, one after the other. And then the counsel on the other side would cross-examine them each time they put a witness in the box. We understand they are dealing with the second witness now. So the next agenda will be for trial to continue in respect of this particular matter. I see. And then we also need to talk about another issue that took place in court today, because 2 former directors of the National Service Authority were a no-show in court during the arraignment today. Both former executive director of the authority, Osei Bentry, and his deputy, Gifty Oware-Mensah, are facing criminal charges, including stealing and causing financial loss to the state. Now, when the case was called, lawyer for Osei Bentry explained notice of the hearing was received only an hour prior, and that his client was in Kumasi at the time of the hearing. Now, eventually, it was agreed that Osei Bentry will present himself to NIB on Monday. Now, that brings us to Gifty Oware-Mensah, because that one is really straightforward. She's sick and in hospital, which is why, through her lawyers, she presented to the court a medical excuse. Now, the parties will now return to court on Wednesday, October 22. But you've got some details. All right.
But that's just a summary of what happened in court today. all we're looking forward to.
I took the wind out of your sail.
Yes, I tried to say that in one of the instances, the case has been adjourned indefinitely. That's because prosecution is expected to serve a hearing notice that they are unsure exactly when it will come on, but likely to come on within the week next week, but no specific date has been given by the court. But in respect of the second person, that's Gifty Mensah, hers has been adjourned to October 22, and that's because they were able to show the court an excuse duty, to which prosecution had actually confirmed that, yes, indeed, they are on notice that she's not well. So for that reason, they agreed that they take a date to come back on October 2 for that to happen. When they come back on October 2, and both accused persons are there, but mind you, they are tried separately. Yes, in different courts, actually.
Right.
And this in itself is quite unique, because in the previous...
It's the same matter?
Yes. In previous instances, we've seen that persons who are involved in the same thing, they are tried in what, but in this case, they are tried in separate courts. So the attendance of one or the absence of one does not affects
the other.
Yes.
I wonder what the strategy is to try them separately, even though, you know, the crimes are very similar. And connected, so to speak.
Well, so that is for prosecution to explain.
Yeah.
And usually, like we say, prosecution itself, they have a lot of discretion to do some of the things that they do. But when they are pushed to explain why they are doing this, I mean, there could be some justification for it. But in essence, this is what happened in court today. No show in respect of the National Service Authority scandal. The ghost names.
I mean, when you hear the excuse from Isibenchi's counsel that they had only received the notice of hearing an hour prior, I mean, under what circumstance does that happen?
Well, so ideally, you are required to get that charge sheet minimum 3 days, and that would suffice for service. However, when you serve shorter than that, we call it short service, for which reason you can raise issues. But what we do see in practice is that more often than not, prosecution can call you and ask you to meet in court. They hand over the charge sheet to you, and then you take it from there.
Right.
I mean, I have experienced it personally. But where the service is so short that you cannot even call your client to show up, you can raise that as an issue. And the courts, more often than not, will grant you that opportunity to come on a different date. And to think that this person was not even within the jurisdiction at the time the court was called, I mean, the case was called, it was only fair that they would allow him to come on a different date. And that's how come prosecution has now been asked to serve the hearing notice on them so that they know exactly when they're coming to court.
Right, Dennis, thank you so much. Always a pleasure having you here with me in the studio. Give it up for our resident lawyer. Coming up, the newly unveiled United Party may have to brace itself for what appears to be a major storm looming by way of a lawsuit. I'll give you the details when I come back. You don't go nowhere. Welcome back. Good to know you're still with us here on Ghana Tonight. We're live on TV3 and on 392.7 FM. I'm Keminni Amanor. Tonight, the question is simple. Could the NPP want UP back? What am I talking about? Let me explain. Now, Alan Tremanting, a former member of the NPP, launched a political party named United Party. Now, that sounds unproblematic, right? Wrong. At least for the Wale Wale Member of Parliament, Dr. Tia Abdul Kabiru Mahama. He thinks it is problematic. His reason is steeped in the NPP's history. Take a listen.
Yes, but first and foremost, it's not an NPP decision as a political party. I am only a member of the New Patriotic Party who has been elected on the ticket of the New Patriotic Party to represent the good people of Wale Wale as their lawmaker. And the laws of this country are sacred, and that if there's any potential breach of any law, there's a need to bring finality and clarity to that particular matter so that everyone will be at it. The government of my case is that the United Party was a political party formed on the 13th of October 1957. That party was dissolved following the passage of a law by the National Assembly to make Ghana a one-party state. But the history of the now New Patriotic Party, which was formed somewhere in July 1992, was actually having his roots. It's taking his root from the United Party, led by Abrefa Buja, K.A. Buja. So one cannot understand why in October 2025, Mr. Alan Tremanting is forming a political party and using the name of a political party which the NPP tradition is dragged from. You are basically robbing the New Patriotic Parties of its heritage if we allow the name to stand. And though the Section 10 of the Political Parties Act clearly prohibits the use of a name that is likely to send confusion in the minds of people, I wonder why the Electoral Commission went ahead to still give them the provisional certificate to offer it. Nonetheless, admit that it's a provisional certificate, and then subject to any petition, they are bound to review their decision. I have just made provision or reference to the Political Parties Act, which is the laws of the country, which is about the naming or taking names that are similar or that are likely to bring confusion in the minds of people as to which political party you are referring to.
Wale Wale MP, Dr. Kabiru. Now, let me clarify any confusion with the matter. The NPP as a party has not officially responded to this. Now, this is the lawmaker, Wale Wale lawmaker, a member of the party, who's hinting of legal matters as far as the name United Party is concerned. I'll bring in now Nanayao Sapong. He's a national executive member of the United Party. Nanayao, let's look at this matter as Dr. Kabiru sees it. How does it come to you?
Emily, good evening. How are you? I see after you listened to Kabiru, you had a beautiful smile on. It's an interesting moment in the political history of Ghana, and Kabiru trying to push into the legal matters from where he sits. It was unfortunate, but I think that Kabiru would have to take his time when it comes to issues of legalities and issues of political history as a young man, and study before he responds to any of such comments. And he may rather fair these kind of questions when they come to him, to his general secretary or party chairman. That would be better. Now, moving on. See, he's talking about history that happened in the 1950s and the 60s. And he forgot that we are in 2005. And he has forgotten
2025.
2025. And he has forgotten that we are using the 1992 Constitution now. He has forgotten also that the Electoral Commission is an institution that is established by an act, and for that matter, there is a procedure in the act. Kabiru has also forgotten that there is something that we call the Political Parties Act. I believe Political Parties Act 2000, Act 574. And maybe he has forgotten. We'll try to remind him that there is a procedure that has to do with the registration of a political party. Now, he might be going around section 8.5 to 10 thereabout, that and section 9. If we are there, I mean, he's probably he needs to read to understand that the section 9 of it talks about the conditions for the registration of a political party. Section 10 also deals with the prohibition of the use of certain identified symbols and so on and so forth. First of all, we have not taken anybody's name. If you go into the Electoral Commission's register, there is no name in the current Electoral Commission's office called United Party until we had submitted our documents. Now, if you go into the Electoral Commission, they do not register ideologies. Neither do they register history. They register political parties, and they register them by name. And if he's talking about history and ideologies, he should have been told that even in current time, I don't want us to go into the 50s. In current time, in 2024, in July, if you recall, we had what we call the PNP that came out of the PNC. And the PNC, if I may recall, submitted a petition to the Electoral Commission challenging the use of the name PNP and the symbol. You know, they picked the original name PNP that brought Liman into power, and they picked the original symbol. What was the decision on the prima facie?
I see.
There is an authority to this effect. So it's embarrassing to hear my friend to sit on a national television and say we are going to court. To do what? To sue Alan Chamantin that your history is being that your ideology is stolen. Who steals an ideology?
But I see. So how does the United Party of 2025 separate itself from the birthplace of the NPP of today, which is also the United Party?
Which we are talking about ideologies. We are talking about principles and traditions. We are talking about beliefs. I do not think that before or at the creation of democracy and politics, the ideology to the left was created for some people, and the ideology to the right was created for some people. Once you have a belief in it, you can take it and move on. But we are even saying that we are a centric party. We believe in the right, that which is good at the right. We believe in that which is good at the left. We bring it to the center, and we propose and we pitch pragmatic solutions. We are putting Ghana first, and that is what is most important. The point I'm trying to make is that if I believe in the principles of social democracy, and you think that you are the person that brought social democracy, then what happens to the founders of that the ideology? Do they also come to Ghana to sue us? I'm just asking, I'm posing a question. I am happy that he's not talking about the fact that he's going to sue us for the use of the name, but rather going to sue us that a history and heritage that they have destroyed is being taken and would be well positioned by another party. Does he believe in the principles? If he goes into the main history of the UP, does he think that there was power of arrogance then? Does he think that in those days?
I see. So as it stands now, the NPP has no claim to UP or United Party at all. In name, in action, nothing at all.
Emily, these are ideologies. It is there for everybody. It is there for everybody. Do you not think that Nana Kunedu Ajimai Rawlings' party has similar ideologies to the NDC? Do you not think so? Have you read the history of the CPP? the lawmaker, does he understand the history of the NPP, where it came from, how the separations came? Does he know that even the ex-war president of this nation, Nana Addo Dankwa Akufo-Addo, once upon a time followed his uncle to form another party based on that same ideology, and was, I think, a deputy secretary or a general secretary to that party? Does he know? They should take their time and read history. And they should take their time and look into the laws.
So I take it as Alan Tremontain's United Party is here and is here to stay.
Now, there is my provisional certificate. We are opening our offices across the nation. We are focused, my dear. We are forward-looking. We are in to present that alternative Ghanaians are looking out for. We are not in to do battlings in court. We are in to present to Ghanaians practical economic solutions. We are in to present to Ghanaians a leadership of integrity. Leadership that would enforce laws and order. Leadership that would present to Ghanaians discipline. That is what we are looking out to do. Not Nana, to be blooming in courts.
So Nana, just before you go, I introduced you as executive member of a national executive member of the United Party. What position is that?
I'm an interim deputy general secretary, and I still remain the political assistant to Alan John Tremontain.
Thank you for the clarity. Nanaya Sapong there, and he's just told you who he is and his designation. He's a national executive member of the United Party. Just a quick thing, quick things to note for tomorrow, 7 a.m. Alfred Okanse will be here with his team of panel members. He'll be here with his team. The panel there on your screen: Edu Tamaklo, Dr. Zato. We're seeing Professor Jampo come back after a while. Solomon Owusu there. All the people you want to hear from are on from 7 a.m. tomorrow. On Sunday. Yes, why you should tune in at 1 p.m. right after the midday news. We'll go in depth into the story of United Party with their very first chairman since their outdooring this week. You want to stay on 1 p.m. for hot issues as I bring you that conversation. I'm Keminni Amanor. It's been a pleasure coming your way with another edition of Ghana Tonight. I'll see you same time next Friday. But if you can't wait, and I think you can't, join me at 1 p.m. on Sunday for hot issues. Bye-bye.
Ghana Tonight is brought to you by Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.